Hello everyone, this is Rajiv S from immigration.com, the law offices of Rajiv S PC. Since the Obama's executive action was announced on the 21st, we've done a community call with a couple hundred people, and I did a Google Hangout yesterday, but none of the recordings were entirely clear or cogent. I wasn't happy with the quality of anyone. So I'm recording a separate video for you, which is this one, just to bring it all together in a concise manner. So let's begin with what we do know. I am on my blog, and here's an entry. The first on 21st, you will notice that I posted the same day. So here's what we know. These are the points we are sure about. USCIS is about to publish the final H-4 work authorization regulations. What is the approximate date by which we can have that? Probably December. Because if you look at the proposed regulation, it says that by December of 2014, USCIS would have finalized the rule. Okay, what does it mean for us? And in both our conference call and the Google Hangout yesterday, there were a lot of questions raised about this. So let me sum it up for you as I recall it. The H-4 proposed regulation said, in order for the H-4 holder to get work authorization, the H-1 holder must meet one of the following two requirements. One, they must have either an I-140 approved or must have a PERM pending for approximately a year so that they've received an H-1 extension based upon the PERM, which means 7th or 8th year extension based upon PERM. So either one of those two requirements must be fulfilled. Okay. If you fulfill those requirements, your spouse can then get work authorization. We like this work authorization if parallel visas are an indication like L2 or derivatives of e-visa. The way it would work is that the H-4 work authorization would be a blanket work authorization. And I'm basically extrapolating based upon what we already know. So from other visas. So the employment authorization would be an open market employment authorization that would allow your spouse to work 1 job, 2 jobs, 10 jobs, not at all, or start their own company. I don't see any problem with any of those things. Okay, moving on to the next thing, improving the employment-based green card backlogs. Initially, when this proposal was floated, there were two very exciting things in there. One was that President Obama wanted to do away with the way the current employment-based green cards are counted. How are they counted now? So if you have 5 members in your family and you are the H-1 holder in the family whose green card is going on, and 4 others, so you were considered as 5 green cards. So 5 numbers were used up from the priority dates when your family got your green card. And President Obama said we should count only 1 green card because really the employment-based green card is only 1. However, I don't see that in here. Second thing I don't see is that they were going to put back about a couple 100,000 visas, employment-based visas that had fallen off and they were not used because of the inefficient way in which the government issued visas, green cards. Okay, so President Obama said, let's make visa issuance more efficient so that no immigrant visas are wasted. And second thing he wanted to do was providing for better AC-21 rules. I'll come to that in a second. So I'm disappointed that we don't have concrete directives from President to implement these two processes. That would have made things a lot easier and made EB2 and EB3 categories go a lot faster for those countries, including India, where these categories are backed up tremendously. Okay. What he has said is that within 120 days, he wants to see proposals from the government agencies involved to show him how can things be made more efficient. Okay, my concern is this, and I've said this before: the will of the presidency will be tested not so much in ideation. You can have all kinds of ideas, but implementation. You know, if you don't implement these great ideas, this is not going to go anywhere. Okay, so we have to wait and watch and see what the government really wants to do. Are they just wimping out, or are they really doing something concrete for legal immigration. Okay. The second part of the visa issuance process was providing for better AC-21 rules. What is AC-21? AC-21 is a law that was passed back in October 2000. Congress said people are suffering, employees are suffering because their green cards are taking too long to come through. So let us make it easier for them by, number one, making it easier for them to change jobs. As long as they do it to a same or similar job anywhere in the country with any employer, we will let them carry on with the same green card process and not have to make them start all over again. So basically, what does that mean? Once your I-140 is approved and your 485 has been pending 180 days, under AC-21 rules, you can change to any employer anywhere in the country as long as the jobs are same or similar. The problem is this law was enacted in October 2000 and we are now past October 2014. For 14 years, we don't have regulations. And I was telling some of the IT people who were logged in, I said, it's like having a system overview without the code. Okay, so you really unless there's code, unless there is a comprehensive set of definitions, you are not going to be able to decide what is safe and what is not safe. So how do we know what is same or similar job? And Obama said that they'll make it clear. Okay. Next thing about the students, they said what we will do is one, we will expand the OPT time from 29 months for STEM students to perhaps even greater time. We like that, but they want to create tighter controls, connections with the university schools degrees. Not sure what that means, how that would play out, and they also want to make sure the local workers are protected. Is it going to be like a mini PERM, like an LCA kind of thing that they can implement, or are they going to implement some sort of requirement that we must pay prevailing wages like we do in H1s? Not sure how that would play out. Fourth point was creating opportunities for foreign investors, inventors, researchers, and founders. Okay, founders who are founders of startup companies, we can bring them in on national interest waiver. What does that mean? It's a category under EB2 which is available to those people who either have advanced degrees or are exceptionally qualified. They have exceptional qualifications. That's the first requirement. And then if they are inventors, researchers, and founders of startup companies, they can come in through an EB2 category called national interest waiver. National interest waiver, when it was initially floated back 10, 15 years ago, was a very reliable category. Pretty much anybody whose work was of national implication, such as environment, or some key areas of research, we could get them a green card on national interest waiver without having to go through the labor certification process. Then came the New York Department of Transportation decision, a case that was decided by the Administrative Appeals Office, which laid down impossible requirements. And one of the requirements, which is kind of implicit in that decision, is that we must be able to show how, if the person for whom we are doing the green card were to leave the US, a US interest would suffer. Now, that's an impossible criterion to meet. Tomorrow, President Obama could leave us and we would not miss him. Okay, when we're not going to miss the first citizen, how are we going to miss somebody who's applying for a green card? It's an impossible criterion to meet. So national interest waiver, they said we would expand to include inventors, researchers, and founders of startup companies. But it's an EB2 category. How does one get in? It takes 6-7 years under EB2 categories to get your green card. So then they said we are going to create a parole. If you look at the point A here, by the way, this is my blog. If you create a parole, which is a temporary but quick measure through which you can come into the US. So sort of like an H1 visa green card situation, you would come in on a parole. Okay, if you are an inventor, researcher, and founder of startup company, as long as you have raised financing or you otherwise hold promise of innovation and job creation through development of new technologies or cutting edge research. So if you have raised money, how much money? This is somebody asked me that in the Google Hangout yesterday, and I said there is no limit. It's not going to be definitely, I hope not, the $500,000 or million that was required under EB5. EB5 will continue as it is. Investment-based green card has not been touched. Remember, Obama cannot change the laws. He can change the interpretation of the laws or the execution of the laws. I'll cover that towards the end, what he can and cannot do. Okay, so we have an exciting opportunity here, possibly, depending upon how it's implemented, for inventors, researchers, and founders of startup companies. Okay, point 5 on this write-up, we want to create guidelines for what is an exceptionally qualified or advanced degree individual to come to the US. Okay, so that headache of who is an exceptionally qualified individual, etc., that intend to clarify that, and there's a reason for this. Right now, the EB1, extraordinary ability, outstanding researcher, professor categories are full of holes. You never know whether you can get your case approved or not. You could go in with the best case possible and end up losing the case just because the officer who looked at your case did not think that you were exceptionally qualified. The guidelines are very, very vague, and they have only gotten tighter with time without there being support in regulations or law for that kind of tightness. So hopefully, when they loosen or define the national interest waiver categories better, we will have better results towards the end. Ultimately, like I said, it's going to be about implementation. Okay, the last point is, and this will be welcome addition to many, many companies who have a genuine L1B situation. What's an L1B? When you have a company with multinational presence, IBM India, IBM USA, or even smaller companies, mom and pop India, mom and pop USA, if you have an individual who has some unique information, unique knowledge about your company's products, processes, etc., you can bring them in on an L1B program. Why we like it is because it's not subject to the quota. Okay, so we don't have to worry about the H1B quota. The problem is current L1B program has been made so tight, it is impossible to qualify anyone. I'll give you an example, and this is from one of our cases. We have a case of a European company, multinational, who are a Microsoft partner, who have developed an infrastructure for bringing together with Microsoft Exchange all your mobile platforms. So your mobile telephones, your iPads, your tablets, everything is all brought in under one roof, consolidating the data. It's a fairly large code, and I think their licensing is pretty expensive too. When we wanted to bring in the chief architect of that program, we had to submit close to 300, 400, 500 pages, I think almost 600 pages of information just to convince the government that this was a clear L1B case. It was approved, but these cases have gotten very difficult to get approved. So this is a welcome addition that they are going to provide clear guidance on what is an L1B program. Now, this is in a nutshell the program as I see it. One thing important that I want to mention, there are some inexplicable comments about making green card easier or the process easier. And it appears that they relate to a proposal where if you are at the I-140 stage, the government will allow you to file 485 without having for you to wait for your priority date to be current. Very, very important provision. So you can file I-140 and 485 together. Okay, but I don't see any clear indication of that. It was proposed, it was floated around, but in the final document that DHS issued, there is no mention of it. I don't see any clear mention of it. So I'm wondering how they are going to implement that, or whether or not they are going to implement that. What is the advantage of that? One, the employee can become free to do an AC-21 transfer after 180 days of 485 pendency. You don't have to wait all the way for 8 years or 9 years for priority dates to become current. You can change jobs. And the next thing was that they have said this, that we want to make the career progression easy. Let me explain to you what that means. So right now, if you file a labor certification for a software engineer and you are done with your I-140, if you want to get promoted, you would have to start all over again. And this rule, or if this is implemented, it would, after your 485 has been pending 180 days, having filed it immediately with the I-140, You could take a promotion and the government would allow you to take a promotion and not have to start the green card all over again. Okay. Some questions were raised about AC-21 in general yesterday and also in the conference call on Friday. And I want to address those real briefly. How does AC-21 job transfer process work? Okay. So currently, let's say you've gotten your I-140 approval and you waited 8 years for priority date to become current. You filed your 485. What if you had to leave the employer or you got laid off before 180 days? Do you lose your green card? And the answer is no. What USCIS has said is that we don't care what you do in the meantime. But once we ask you for an employment letter, at that time 180 days must have passed. So when you respond, and let me give you an example. Let's say you filed 485, I-140 is approved. You filed 485. After 2 months, you got laid off. Okay, are you going to lose your AC-21 right automatically? Are you in trouble? And the answer is no. If USCIS sends you an RFE 3 months later, which is 5 months into your 485 180-day period, by the time you respond, 180 days are over, government will accept your AC-21 right, which is a very, very good thing, which is a good way to read this law. So that, I believe, would continue. Only thing is it gets pushed up front towards you a lot faster. Now, you don't have to wait 8 years or 7 years or 9 years to file your 485. You can accrue the AC-21 right away. And if you go into career progression with another employer or the same employer, or you go into a related job, both these things have been mentioned in the Obama action. So both of these situations will allow you to carry your green card forward. Now, having said this in a quick and hopefully cogent presentation, I want to come back to how far the president can go. Where does he derive his authority? We need to understand the structure of the government in the United States, or the governance is based like this. There are 3 branches. There is the legislature, which is Congress. In India, it's Parliament. Same as Indian and Australian and UK or Commonwealth countries. Same kind of structure. We've got the legislature who is charged with the responsibility of making the laws. What is the law? Law is an overview of the way Congress desires to have certain sets of rules enunciated. The executive has 2 responsibilities. They interpret the law to the extent necessary for implementation. So they interpret to implement. And second, they're in charge of implementing. So they can pick and choose their implementation priorities. Okay. The judiciary, which is the courts, interpret the laws and decide whether what did Congress intend, whether the will of Congress has been followed. Is the law constitutional? If a law is unconstitutional, despite it being the will of Congress, it will be negated, nullified, voided by the courts. So 3 branches of the government. You've got making of the laws, interpreting for implementation and implementation of the laws, and you've got the interpretation of the laws in general. Now, the president derives his authority to act, even on this executive order, from 3 areas. One is from the statute itself. When the law is written, it might give him some delegation of authority. It usually does. It's implied or expressed. Second, the authority comes from interpreting the law to the extent necessary to implement it. So he can interpret the law any way he wants. If he wants to count visas a certain way, he should be allowed to do that. If he wants to interpret AC-21 in a certain way, he should be allowed to do that. So that's where his authority comes from. And his authority to act on deciding not to deport certain people, which is what we are talking about when we talked about undocumented people's relief in this law, which says, look, if your child is a U.S. citizen or green card holder, we won't deport you. That doesn't mean we are going to give you permanent rights to live in the U.S. We just won't deport you. And we'll also expand the DACA eligibility for people who are already been given that eligibility. So more people can qualify under DACA. Those are the two key components. Can he do that? And the answer is sure, why not? He should be able to implement the laws, execute the laws according to his priorities. If he wants to deport criminal aliens first, he should be able to do that. And this is what he said. He says, look, if you are here with those two, under those two criteria that I just mentioned, which is under the DACA program, you qualify, or child being US citizen or green card holder, you qualify. As long as you're willing to register so that we know where you are, and you are willing to go through a criminal background check and pay your taxes, we will let you not be deported. Okay. Now, one of the questions raised yesterday was, what can Republicans do? They don't like these laws. They want to act and pass a bill. Well, first of all, what is it? 500 odd days that they have sat on the Senate bill, which was a bipartisan bill passed by the Senate. They have not done anything on the House side. Funny thing is, funny not in haha, funny as in odd, almost bizarre, that if the law had been voted upon in the House, it would have passed. Boehner is to blame. Republican leadership is to be blamed for not bringing immigration reform to a vote. What can they do now? Can they sue him? Yeah, but they're probably not going to win. Okay. Can they pass a law overriding this law? Remember, president can veto any law he doesn't like. So if they pass a law and send it to him, he can refuse to sign it, pocket veto it, general veto it. If he vetoes it, it has to go back to the chambers, to the House and to the Senate, and they have to pass it by 2/3 majority. So if there's a quorum and it votes 2/3 to overrule the veto, only then they can override the president's refusal. So that is very unlikely to happen. Okay, I just wanted to do a very, very quick presentation. I want you to remember, if you want to keep following up on this, go to our website, immigration.com. You can follow my Twitter feed. I keep it quite active. You can also go to our YouTube account. You will see we have a very active YouTube page with lots of playlists, lots of new stuff. You can go to Google Plus. You can go to my LinkedIn account, all from immigration.com. You'll see that on LinkedIn, I have people commenting upon my write-up, and I have, of course, answered all the comments. You'll see the comments right here. So you can go there, but everything starts from immigration.com homepage. Just go to the homepage and you'll be able to follow my Facebook page. I answer there. You can download our free apps. I actually, if there's something urgent, I will send you a pop-up message on the app. There have been thousands of downloads. People have liked them. So you can do any of those things. And I will be updating. Follow the tweets for sure, because I will be updating very, very frequently. Start with immigration.com homepage. People also leave their comments, of course, on my blog. So if you go to immigration.com, where's my blog? Oh, right on top. So if you go to my blog right here, you'll see we have a provision to provide add comments here. Okay, and I respond to comments. You'll see that I've responded to these comments. Okay, hope to be hearing from you folks, and I'll keep you updated. Stay tuned.
Every other Thursday at 12:30 p.m. Eastern Standard Time, we host free community conference calls. Everybody is welcome to join. Some people post questions ahead of time. You can take membership in our forums. All of the details are there on our website, immigration.com. You can take membership ahead of time, and it's instantaneous. It happens right away. And post your questions beforehand, or you can just log in. The phone number and all are provided: 202-800-8394, 12:30 Eastern Standard Time, every other Thursday. We have free apps for both Apple iOS platform for your iPhones and iPads, as well as for Android. Just look for immigration.com, the period dot, and the application should show up.